Good afternoon, and welcome to this special event, the latest installment of the George Washington Leadership Series. For over 30 years, our guest today has helped to shape the legal environment in the United States. Considered by many to be the leading antitrust and commercial litigator in the country and an expert in international law as well, Bert Rein began his legal career as a Supreme Court clerk for Supreme Court Justice John Marshall Harlan in 1966. He later served in the State Department as Special Assistant to the Undersecretary of State for Economic and Business Affairs from 1969 to 1973. During the Reagan administration, Mr. Rein worked on the transition teams for the Department of Justice as well as the Federal Trade Commission. Mr. Rein is a founding partner of Wiley Rein, a Washington, D.C. firm that is consistently regarded as one of the premier legal practices in the United States, employing over 275 attorneys who practice across 22 areas of the law. Mr. Rein is currently serving as counsel on two potentially landmark Supreme Court cases, Shelby County versus Holder, and that would be Eric Holder, the Attorney General, is a challenge to the constitutionality of the renewal of the Voting Rights Act, and Fisher versus the University of Texas is a case that challenges race-based college admission policies. Mr. Rein will share his thoughts with us on these two cases, the practice of law today, and perhaps also reflect with us on the legal profession with the perspective of someone who has helped shape the field over the past many decades. When I say that Bert is a visionary and one of the best lawyers in America, I am only repeating the praise and the accolades that his peers have repeatedly heaped on him. Ladies and gentlemen, please join me in welcoming Mr. Bert Rein.
Well, thank you for that introduction. Couldn't have written it better myself. Probably taken out of our website puff piece. It always reminds me, it's an old story, but it's attributable, I think, to Jerry Ford. He had been at a political gathering way up north in Michigan, and Betty was with him, and he was introduced as that great American Gerald Ford. And so on the way home, he said to Betty, how many great Americans do you think there are? And she said, one fewer than you think there are. So with that, I will turn to substance, and so don't embarrass myself anymore. I appreciate the opportunity to speak today, and I see many of my neighbors here, and hopefully a few students that might learn something. And what I'm going to talk about, and I thought would be interesting, is not just the merits of the two cases that are pending. They're both not yet decided, so I hesitate to tell you who's right and who's wrong. We'll find that out. They're both argued and submitted, but not decided. But also a little bit about the process. How did we get those cases to the Supreme Court? How does the system function? And what kinds of decisions do you make along the way that shape the case and also determine whether it will or will not eventually result in a Supreme Court decision? And, I think you've all, not all, but you may all have read about the same-sex marriage cases. And what's interesting about those in this context is there they are at the Supreme Court, and they've been argued over 2 days, but everybody's talking about, are they going to make a decision at all? Has the case been shaped in a way that's going to result in a decision, or are they going to go off track on some kind of procedural issue, and with all that effort and all that anxiety, nothing will happen? And it's not entirely impossible. In fact, I think in one of the cases, it's entirely possible that it will all turn on whether the proper party's in front of the court, and if not, we'll just dismiss the case on that basis and the end of it. So, I think what we're talking about now is, well, how does it occur that you get something that will actually not only get there, but result in some kind of resolution of the controversy which was brought it there in the first place? So with that, I think it's sort of a common form of expression in American life. You're really mad at somebody, you're in a dispute, you say, I'm going to take it to the Supreme Court. But that's easier said than done. And if you look at numbers, each year, certainly over the last 5 years, the court receives about 10,000 requests to be heard, 10,000. And they take and decide about 75 to 80 cases a year, so odds are not good. Now, that's a little bit deceptive on the numbers because those petitions to be heard are split between what they call the printed petitions, that is coming from litigants who have the money to afford to, hire a lawyer and present their petition in writing and make a major effort, and what they call the miscellaneous docket, which are largely, people operating on their own and almost all prisoners in various institutions who really have little else to do except go to the Supreme Court and hope. But occasionally, one of the cases from that docket makes it through. And of the 75 to 80 cases, about half are criminal because the Supreme Court supervises both civil litigation and criminal litigation. So if you're trying to count odds, there are about 1,500 to 2,000 people seriously petitioning the court to be heard in any year. And of those, I'd say the preponderance of those, 2/3 are civil. So if you just take rough numbers, it's about 1,200 or so, and about 40 are heard. So it's 1 in 30. It's not a sure thing. And the question is, well, how do you get to be the one? Now the court, tries to give people a little bit of advice on how they're going to decide what they're going to hear. And they have a couple of things. One, the Constitution itself mandates that the court has what they call original jurisdiction. You can get your case heard in the Supreme Court if you happen to be a state fighting with another state. It doesn't happen too often, but those cases must come to the Supreme Court. If you're an ambassador and you have a challenge to you in that capacity, the Constitution says those cases are heard originally by the Supreme Court. Those cases are few and far between, and most of them have been water rights disputes or natural rights disputes or boundary disputes between states. And even there, what the court does is it appoints a special master to hear you and only reviews what the master does. So the Supreme Court is not a trial court. Everything up there is a review of something another court has done. And in determining what to review, the court has what they call a Rule 10. It provides a kind of guidance to lawyers about what matters and how should you tell the court your case should be heard. And there are three basic kind of appeals you can make. One is that you have an important question of federal law, and the lower courts are not deciding it consistently, because ultimately the Supreme Court supervises the court system. And you'd like to have a unity of decisions all over the country. For example, if in one circuit in the country, there are 10 circuits, there are 11 circuits, and they're geographic. So if in one area of the country somebody's saying the rule about copyright is X, and your rights are protected one way, but in another place the rule is Y, the opposite, you don't know how to function. And everything becomes randomized. Where are you? One of the functions of the Supreme Court is to take those cases and unify the law. So they're very attentive to situations where important questions of federal law have been differently decided in appellate courts across the country, and they need to unify the law. That's something which is very helpful. Doesn't happen all the time, but it can be helpful. A second rule is where there's a conflict between what a lower court has ruled and a previous Supreme Court decision. In other words, where it appears that they need to discipline the lower courts because they're not following established precedent or misunderstood it. And sometimes that means the lower courts are rebelling or mistaken, and sometimes it means that the court itself realizes the precedent is not clear, and we are having a hard time using our precedent to supervise the court system because they don't understand it, and it can't be easily applied. And the court itself may say, we ought to take that up and say it again in ways that will be meaningful in the adjudication of cases in the lower courts, because we are in charge of the system. We're running a system. And the third is an unusual thing. They call it a gross departure from the usual course of judicial process, which means some judges are real maverick, and we just kind of corral him. And it's happened over time. And in fact, there have been historic instances where the court has literally removed a judge in a lower court from hearing a case and instructed it be transferred because they think the judge has a bias and is acting contrary to law. So when you're going to write a petition to the Supreme Court, you've got all of that in your head. Which of those rules are going to come under? Why am I going to tell the court this case is of unique importance? And in selecting among those 1,500 cases, please take mine. And your ability to do that just doesn't start when you start writing the petition. It starts when you start the case. How do I shape this case? How do I determine whether I've got the kind of issue they'll want to hear, and how do I create an environment where they're going to want to hear it? So, just mechanically, when you come to the Supreme Court and you ask them to hear your case, you're entitled to file a written petition. You're entitled to 9,000 words. Sounds like a lot. It's about 38 printed pages. And in that, you kind of explain what happened before and why the court should review it. Your opponents get the same number of words, and you can reply to it. So there's a lot of words in front of the court, remembering that in order to process all these petitions, they're going to look at about 50 a week. So you really need something that's going to catch their attention, or else it's going to be, well, we don't need to deal with that one. Human nature being it is, you've got to sort. And when you're trying to sort 50, and you're meeting in a conference and going through all of them, it takes something to catch the attention of the court. Now, one thing that's happened as part of the process now is that many people say, well, I need some friends. I need other people to tell the court just how important all this is. And so they run around and try to get other people to submit what are called briefs, amici briefs, which means I'm a friend of the court. I just want to tell you this one really matters, really important. And this is not just done individually, but there are major institutions in Washington that consistently lobby the court in that way. You can't lobby the court by running around knocking on their door, but you can write briefs from a consistent point of view. And the U.S. Chamber of Commerce, for example, has a business interest. So it will constantly appear before the court saying, this case really matters to the business community. And you really ought to take this up because we really care about it. And over time, if you write consistently and you write from a selected point of view, you can have an influence on the court's docket. And major institutions do it. Trial lawyers do it through the American Constitution Society. The business community does it. And there are quite a few foundations that also, from a point of view, will do it. They don't write it in every case, but when they think the case is important, they'll come in and say to the court, pay attention to this one. And it does help get some attention. It won't guarantee anything. You can have all the help in the world and get nowhere. But it's something you do. The court has conferences. That means all 9 justices meet together to vote on whether to take a case, which cases they will take. And there's a rule of 4. Of the 9 justices, 4 have to say they want to take your case or it won't be heard. So you just can't persuade 1. You got to persuade 4. And that's not always easy to do. And one other thing to consider is even if you think you've got a case that's of great importance, there's a real division, even if the lower courts are split on it, you've got 9 people thinking, if we take this case, can we do something useful? Do we have enough uniformity in our point of view that we can write something that'll be meaningful? Or are we going to write 9 opinions, that'll just confuse the dickens out of the system? So you're writing not only to say it's important, not only to say it needs to be done, but you're trying to say, and there is a way through this thicket in which you can make a meaningful contribution to the future of the law. Because if they don't feel they can deal with it successfully, it's easy enough to say, we'll see another case like this. Maybe we'll have a better understanding of our own positions. Let's wait a while. And that happens too. So all these traps are out there. So how do we get these 2 cases to the Supreme Court? We could say luck. That would probably be true. But these 2 cases really started with a foundation that was looking for a vehicle to further its cause. And with the affirmative action case, their view was that we had come to a time in the country when people deserved equal treatment, and equal meant equal, meaning no racial preferences in admissions when they're administered by a state agency or a university. And I expect Washington colleges like this, where the Office of Civil Rights is supervising grants that you get and insists on appropriate procedures. So it has a big, wide spread. And these folks felt it was time to ask the Supreme Court whether race preference could continue to be used in college admissions. Now, strictly speaking, the issue in Fisher was whether Ms. Fisher, who was Caucasian, was deprived of her constitutional right to equal protection of the law when her application for admission to the University of Texas was reviewed and denied under a scoring system in which extra credit was awarded to underrepresented Black and Hispanic applicants. So that was the issue. That's what we wanted the court to talk to. But we had to find a vehicle. You just can't run up to the court and say, that's a pretty good issue, and we think it ought to be clarified. So if you look at the background, what is the court looking at? What's the background against which they are going to try to decide this issue? And the issue of affirmative action in university admissions had been before the court 3 times, 3 significant times in the past. In 1978, It was a so-called Bakke case, and that was a case involving admission to medical school in California. What California was trying to do at that time, as Berkeley, was they had a set-aside for underprivileged racial admissions. They had a quota. They said, these places cannot be competed for by anybody who is not part of an underrepresented minority, and only they will compete for the places. That went up to the Supreme Court. The Supreme Court split all over the place, but basically said, no, you cannot do that. Quotas are against the Constitution. You don't have equal protection if you have set aside and you have people who can't compete for the same places. So that was Bakke. There was a question, well, what does that really mean? You know, it's all over the place. And the fifth vote to turn down the quotas, it was a 5-4 decision, came from Justice Powell. And Justice Powell said, you know, I don't think this is a good idea. Quotas are bad. But you know what? If in the context of looking at the whole person, you kind of sort of looked at, you know, what was their racial characteristic, that might be okay. It's sort of part of you. And, you know, that's the way they do it at Harvard, so it must be good. So, so-called Harvard plan, which is that, you know, you want to put a twist on it, the Harvard plan was an invention of Harvard in the 1920s when they thought that their objective testing criteria for admission allowed too many Jews. And so one way to get rid of them was to go to a holistic system where you could bring out good strapping Western farm boys and say, yeah, it's true. I mean, it had this ugly history, but it turned into a virtue in the eyes of Justice Powell. In any case, so that kind of swam on. And the next big test, 25 years later, was in 2 cases coming out of Michigan. One of them involved admission to the University of Michigan Law School. A relatively small class, about 112. And which used what they called a Harvard holistic system. We just look at the candidates, we kind of look at them and sift them, weigh them one against another, and try to pick a class which on the whole is diverse enough to make everybody's education better. And so that's okay. And yes, we do look at their race, and yes, we have improved our racial composition by going from 3% minority to 12, but we don't let it get out of hand, and we sort of know how to do it. We know how to adjust it. The second case was the University of Michigan undergraduate, much bigger, had to process in a very different way because you're admitting 15,000 students and you're processing 30,000 applications. You can't look at them one against another. I mean, you'd need UNIVAC, supercomputer to do it. Can't do it. So what they had there was a scoring system. They took each applicant and awarded them a certain number of points. And then they drew a line and said everybody above the line is admitted, everybody below the line is not admitted. But for minorities, who they thought were underrepresented, they just gave them a few extra points. Said, you get 20 points free. And that helps, right, when you're drawing a line. But it was open and transparent. It meant that everybody competed. Some people just competed better than other people. The court said 5-4. What the law school was doing, that was just fine. That's holistic. That enhances education for everybody. Diversity is a compelling interest which justifies a departure from equality. What the undergraduate school is doing 5-4, that's terrible because it's a mechanical system. Now, the human mind might have a little trouble, really, lawyers can comprehend that, and maybe Justice O'Connor could get it, but it didn't seem very stable around the country because it's really hard to understand. Look, if you're going to give preferences, why don't you do it in an open, transparent way that kind of controls it by the number of points you award so you know what the heck you're doing, rather than hiding it under the table. So the doctrine appeared to be, it's okay to use race preference as long as you don't talk too much, keep it quiet. And so our clients believed that this was erroneous. So why did we pick on Texas? Apart from the fact that Mr. Wade lived there, we didn't have a thing for Texas, but the Texas admissions program created a somewhat different foundation that allowed us not to have to attack what had been done before head on. And the reason for that was the University of Texas had a kind of 2-tiered admission system. Under state law, they were obligated to admit anybody who was graduated in the top 10% of their high school class in Texas. So they were obligated to do that. As a result of that, and especially as economic times turned more adverse, this is 2008, they were filling up a lot of that entering class out of the top 10. And the top 10 was diversified in and of itself because, of course, the high school populations tend to reflect demographics. So they had, before they went into their selective second tier, about a 25% minority population, mostly Hispanics, some blacks, about 19 and 6. So this was a school that, unlike Michigan Law School, which only had 3% minorities, had a very significant minority presence. And one of the statements made in justifying the Michigan Law School was that you had to have enough minorities so they didn't feel like spokespersons for their race and isolated on the campus. Well, we had a situation where he said, you can't be too isolated when you're 25% of the campus. So this is an attractive target, because what they were doing is after they got through with the top 10, they considered everybody else, and they had a scoring system which added an unknown and mystical factor to minorities who were either Hispanic or African American. And of course they said, it's just like Michigan, we don't have a set rule, we just kind of sort of look, and we adjust, we're trying for diversity. And that was their public position. So we thought, well, this will raise the question in an interesting way. The court can look at it without necessarily saying we're wrong, just saying, well, we said in that Michigan case that you could apply this preference in order to achieve a critical mass of minority students. Of course, they never said what a critical mass was, but this presented, what's the critical mass? Is 25% enough? Or is it demographic? Does it have to equal the demographics of the high school graduating class, which is about 45% minority in Texas? And the other interesting thing that made the case attractive in picking on Texas was the Caucasian admits, as they call them at the University of Texas, were about equal to the Caucasian percentage of the graduating class in the high schools. So you might say, well, if the minorities were underrepresented and the Caucasians were equally represented, who was there? And the answer very simply was, because of the top 10 system, Asian students, who are about 2% of the high school graduating class, were 18% of the Texas class. And so the choice was, if you want to up and if you want to get things demographically adjusted, you'll unfortunately have to throw those Asians out because they're overrepresented. That's what they call them, overrepresented minority. So of course, it gave us a lot of room to play in the case. So that's why we picked those two. And the plaintiff, Abby Fisher, was somebody who was very close to the top 10, had very good SAT scores, wasn't admitted, and had a family that was absolutely dedicated to getting her into the University of Texas. Her parents had both gone there, her older sister had gone there, and so we felt she is going to carry this case. She is not going to walk away. She is not going to quit. Even though there's public pressure, other students look at you kind of cross-eyed, and, she'll stay, and she did. And it's not easy to do that. So you need a plaintiff who's going to stay in the case as long as you're willing to stay in the case. So that's why I brought the case in Texas. You have to bring this case in a federal district court, lowest level of the federal courts. And we had to bring it in Austin because that's where the University of Texas is. And 2 judges in Austin, we got the wrong one. Happens. It's a 50-50 shot. It's drawn out of it's on a wheel. And Judge Sparks had previously been very pro-affirmative action, a very liberal judge. So we figured we don't have much of a chance. But we brought the case promptly after she was denied admission. And we were trying initially, because she was our client, to say, would this judge order UT to let her in, saying, look, we've got the records, we did obtain the records of other people who had competed in this non-top 10 tier. And he said, her record's much better. There's no reason to keep her out. That's a tough way to go because you're asking the court to decide 2 things. 1, are you right? Would it be unconstitutional to use the system? And 2, at this stage of the case, are you going to intervene in that whole system and make them do it over again? Because their answer, in part, was, Judge, if we take out the race preference, we'd have to redo the whole admissions thing because it's right there in the face of the jacket, and all our scoring can be affected by it. We'd have to do it all over, and are you going to make us do that when you haven't yet decided whether they're right? And so, of course, he denied the injunction. That gave us a choice. We could have appealed from that on that record, but we felt that we had not sufficiently documented the way they were actually doing it because there was a lot of mystical language around what they actually did. And so we decided to go on, depose them, take document discovery, really try to figure out how were they making it work in practice. What did they really do when they had these jackets where race was right on the cover? Because in one iteration, they said, well, if you look at the way we score, race is a factor of a factor of a factor. It's like 1/100th of the whole process. And, so it's inconsequential. Really doesn't matter. We're just doing it for eyewash. If you looked at SAT scores and grades, you'd say, well, it appears that you're very effective at 1/100th. So we had to ferret out what they were actually doing, and in particular the fact that they were identifying throughout. And so when they were scoring essays, for example, the person scoring the essays ostensibly scoring just as if it was an English composition, knew the race of the applicant. And why would you have to know that if you were just scoring an English composition? So we took the discovery, we made the record, and the case went up then, cross motions to the judge, each side saying we're right. The judge said, well, it appears to me this is enough like Michigan that it passes muster. So where do we go? We could quit. We weren't going to quit. So then we went up to the Fifth Circuit Court of Appeals. Now, by doing it that way, we'd already gone through, if you look at the timing of it, we'd already gone through more than a year to get to that decision. So she was already enrolled at LSU, going on with her life. We didn't tell her to stay home until this case was figured out. It would have been a little unfair. So we then appealed to the Fifth Circuit Court of Appeals. Well, you go to the Fifth Circuit Court of Appeals, you got to write a brief, the other side's got to write a brief, you got to get it set for argument, they have to hear the argument, they have to write a decision. So how long does that take? We had finality in the district court in August of 2009. By the time the Court of Appeals decided the case, it was January of 2011. And she's halfway through LSU. This is just a question of time. So now we have another interesting question. Do we have a foundation for taking it up to the Supreme Court? What are we going to say to the court to reflect why it's important and why the prior decision is very hard to deal with and very unclear? So we had 3 judges on the panel. 2 of the judges said, look, just like the district judge, this looks a lot like Michigan. They say that they don't have a mandatory system. It's all holistic. It's everybody's judged on their own. It's good enough. And, and they have to reflect the demographics of Texas because that's what will create a better society. One judge, who happened to be the only Hispanic judge on the Fifth Circuit, wrote an interesting opinion where he said, I think this really looks a lot like Michigan to me, so I have to vote to say no. But that decision was horrible and unconstitutional. Let me spend 65 pages telling you why. So Judge Garza wrote that opinion. So then the next question is, well, what do you do now? Is that enough to get the Supreme Court's attention? And we thought, it might be, it might not be. We weren't lucky enough to draw into our panel the judges on the Fifth Circuit who we thought would be very strongly on our side. So we asked them to hear the case en banc, which means you get all 17 of the judges on the Fifth Circuit to review the case. And they split 9 to 8. 9 against 8. We had 8 votes, but of the 9 votes, one was Judge Garza, who was voting to say, yes, I think the Supreme Court's telling me to do this, even though I think it's against my constitutional oath. And with the 8, the chief judge, Judge Jones, wrote a very strong opinion explaining why she thought this case was different from and in excess of what Michigan had done because of the percentages, and because of other factors. That was very helpful to us because now we could go to the Supreme Court and say, look, nobody understands the prior precedent. How can it be applied when you get 17 votes and it's 9-8? That's too close, and the issue's too important. And there are too many other cases not dealing with higher education in which you have said race should not be a factor. Federal employment, distribution of broadcast licenses, a whole host of cases where the Supreme Court has said enough. Everybody's got to be treated equally. So I think that was an important factor for us and allowed us to file the cert petition, which we did. And it took us until June of 2011 now. We're going on from 2008. We're 3 years into this case to get the decision in the Court of Appeals, the 9-8 decision, because they were writing. And so then we filed for cert. It was granted in the beginning of 2012, but it was too late to be heard in 2012 session, which ended, last argument was April, so it was carried over, and we argued in October, still not decided. So that'll show you that, you don't do it lightly and you don't do it quickly. But if you care about it and you can get it up there, then we hope that something fundamental will be decided and that there'll be better guidance. What are the limits of using race as a factor, or can it be used at all? And in what circumstances? So I think that's just an example of just what it takes to have the Supreme Court decide. And just a kind of sidelight on this, one of the decisions we had to make at the beginning was, what are we going to ask this court, this lower court, to do? So one of the things we wanted to do is, say this is unconstitutional processing and she should be given admission. But we thought, this case could take a long time. And by the time we get it anywhere, she might have finished in college. And then what is she fighting about? Does she want to go back and start all over again? Hardly. So we asked for damages. We said, well, she's damaged financially because she wasted her money on what she thought was an application that would be fairly processed when it wasn't. And it was kind of a throwaway line. But the idea was keep it alive, keep some factor alive that will survive any effort to get her in. And fortunately for us, the district court judge said, this damages stuff very confusing. It won't matter if you lose, so let's split the case in half. I'll take that up if and when you win. And so it went on that way. It was never discussed again. We got to the Supreme Court. She had graduated from LSU. So the first thing the other side said was, well, she didn't belong here. What's she fighting about? She's already a college graduate. She can't say she wants to go back. And then they cleverly said to the court, and the only other thing she asked for was $100, and we're going to give her the $100, and that's the end of it. So, and then they went on to say, this is a great lawyer story, she could have asked for damages based on the difference between the cost of UT and the cost of LSU. She could have asked for damages based on her future earnings capacity. And he just went on with things she could have but didn't ask for. So we were able to answer that by saying, it's interesting because the case was bifurcated, so we reserved the right to ask for anything. We thanked them for telling us that there are all these things to adjudicate. So this case has gone forward. And the only other kind, little stories are always funny. One of the things that UT had a hard time explaining was what philosophy, why were they doing what they were doing? And of course the truth was that they're subject to the state legislature and they're trying to keep them happy. That's why they were doing it. But you can't say that. You can't say my compelling interest in using race is to keep the legislatures flowing money to UT. That would be wrong. So they initially said, well, you see, we have, to be more representative of the state, we have to get our demographics closer. When they got to the Supreme Court, they thought, demographics, not the best kind of argument because it looks like quotas, and the Supreme Court says quotas are illegal. So what are we going to say about it? And so they changed lawyers, and they came up with this, honest to God, they did. They came up with this new notion, and the new notion was, well, you see, what we're really doing is that in the top 10 system, we tend to get minorities from underprivileged high schools because they're in the top 10 because the high schools are segregated. We don't have the right kind of minorities. With our flexibility, we get minorities who look like white people, and they blend in better and they enhance education. A remarkable argument, I must say. And Justice Alito was very much amused by this argument. It's one of the most astounding things. Their new lawyer was a former Solicitor General of the United States, and they paid him $1 million for this. It was creative. But when I saw it, I just said, wow. Sometimes the Lord delivers your enemy into your hands. So we shall see what the result will be. But I think, it was a testing kind of argument. And because we had thought through the possibility that somebody would say she's out and the case is moot, we had a kind of resource to deal with it. And had we not done that at the beginning, we'd have been dead at the end. And that, if you look at the marriage cases, that's one of the big problems. You've got the wrong people in the court, and you've got people who don't want it decided on both sides of it, who can't, if I don't get it my way, I'd much rather kick this case out. And we think we've got our case where it's not going to be kicked out. It's been pending a long time, and that's usually a sign you're writing in substance. And the second case, the Shelby County case, again, that was a case started by people who wanted to challenge the renewal of preclearance. Preclearance is part of the Voting Rights Act. It was really great innovation in the 60s, because in the 60s, when Lyndon Johnson started to really push on civil rights, one of the things he wanted to do was push minority and black enrollment and black voting in the South, which is in a disgraceful condition. It was like 6% of the blacks in Mississippi were registered in voting. No matter what the courts did, and the courts had many decisions saying you can't do this, you can't do that, you can't use poll taxes adversely, you can't use grandfathering clauses, you can't use phony tests of literacy. Next day, they'd enact another law, which sort of was like the law, and just evade. It was whack-a-mole. To put an end to whack-a-mole, what the Congress said was, if you have a bad record, if you are a covered jurisdiction, as they call it, there's a formula to say who has been abusing voting rights for minorities. If you're covered, You can't change any part of your voting procedure without pre-clearing it through the Department of Justice. And if they don't agree with you, you're going to have to go to court to prove that it's non-discriminatory, has neither the purpose nor the effect of discriminating. It's a huge burden. And the idea was to really tie up those offending jurisdictions and tell them no more evasions. And that it was immediately tested constitutionally by South Carolina in 1966, and they lost. And the court said, kind of rule of necessity, you really have been wrong. You are evading the prohibitions of the 15th Amendment that says everybody has the right to vote, all citizens can vote, and Congress is entitled in those circumstances to take stringent enforcement actions because the Civil War amendments to our Constitution say that Congress can enforce their prohibitions. You don't have to enforce them through the courts. It says Congress can do it, so they can pass laws. So at that time, the court upheld it, and they came back, and they renewed that act. It was a 5-year act. They renewed it in 1970 for another 5 years. They renewed it in 1975 for another 7 years, making 17 altogether. And that second occasion, it was challenged again by a city in Georgia. It was a much closer case. When the court said then, you know what, looks like the job's not finished. So we're not going to pull the Congress out of its enforcement role. We agree with it. The act was then renewed for 25 years in 1982 to 2007. At that point, it really wasn't challenged because it kind of became accepted law, and people started to really push on, well, what is considered to have a discriminatory purpose or effect? And one of the reasons that prompted us to say we could come after it now, because of the passage of time and the change in circumstance, was that one of those cases, testing what is a discriminatory purpose and effect, kind of threw a cast on the law, actually 2 of them, which made it seem like it had exhausted its original purpose, which is everybody gets to vote, and it become a kind of, this is who's going to get elected, and we need to set quotas for minority legislators and all kinds of elected officials. In that case, what had happened was every 10 years there's a census. When there's a census, we have a one-man, one-vote rule. So states have to redistrict every time there's a census, and they have to redistrict for state elections and federal elections. And Georgia had all kinds of problems getting their stuff pre-cleared. They were subject to pre-clearance, and they said, this time we're not going to screw up. So the way we're going to redistrict is we're going to ask a black legislator to take control of this, and he'll have a lot of minorities on the committee, and then he'll do it right, and we'll all be happy. So the fellow they appointed said, this is for redistricting the Georgia legislature. There are about 13 majority black districts, and they consistently elect a black representative, and that's what we get. But when we look at results, that's only 13 out of 35 in the state legislature, and we're getting nowhere. We can talk, but who are our friends? And he said, the reason that we don't get anywhere is that the Republicans are in charge, and their agenda and our agenda, they're not quite the same. So strategically, what are we going to do? If we just renew the 13 black districts, we'll have 13, and the Republicans will be in charge, and we'll get nowhere. So maybe what we ought to do is take those black majorities down from 80% to 60% and put those black voters into districts where they can vote Democratic, and we'll be able to succeed. So that's what they did. And the Justice Department said, no good. You're retrogressing. You're going to have, because to do this, they had to sacrifice one black majority district, go to 12, and the others were called influence districts. And the Justice Department, no good. Supreme Court said, yeah, it's good. So that controversy, whether the pursuit was really you get a right to vote and to have your vote counted versus you get a right to a result, and the result is whatever the federal government thinks it ought to be, was kind of live. So when this act was expiring, Congress heard it again in 2005 and then renewed it for another 25 years, till 2032. And so then, it looked like, what's the basis for doing this? Where's the emergency that was comparable to what was going on in 1965 when the act was first passed? Is there the power to do it, number one? And number two, who's going to be covered by this? In 1965, the way you identified who was in and who was out to say, were you using a forbidden device, meaning a poll tax, a grandfathering provision, a literacy test in a way that discriminated, A, and B, measuring turnout. Was the turnout so divergent from the national average turnout that it was identifiably effective in screening out minority voters. So the benchmark for the turnout was the 1964 presidential year, because presidential years are a better benchmark. When they renewed the act in the second 5 years, the benchmark was the 1968 election. Third time it was renewed was the 1972 election. So you were kind of moving the benchmark along, moving it along actually to sweep in more, because if you were in forever, until you could bail out, as it's called. After that, they just stopped. So the world of benchmarking stopped in 1972, and this was going to carry on until 2032. It seems a little strange, but politically, it was very difficult to fool around with the benchmarks, because if you did, you might bring in new people who didn't like it, and the easiest thing for the Congress to do was say, renew it, don't change it. But the other thing they did in 2005 was to say, you know, that Georgia decision of the Supreme Court that allows this kind of influence to substitute for actual protection of incumbents, we got to get rid of that. And so they overturned that decision by legislation. So that's why we thought the case was really ripe to be brought. There was a first effort to bring that case, and again, it's a lesson in process, by a small utility district in Texas, which said, you know, we just were created. We never did anything wrong. We're swept into it because we're part of Texas, which is otherwise covered. How can this be right? And so when that case got to the court, because it was controversial, first thing the court said was, well, you know, they've got this provision in the law that says you can be excused from your responsibilities if you haven't done anything wrong, and you haven't done anything wrong, so goodbye. The case was never decided. But the court, in explaining why the case was important, although they weren't going to decide it, and they were going to use constitutional avoidance, meaning we can find some other way to deal with this and won't get the constitutional issue, had said some things that indicated that they were right to rethink this, and that's why we brought that case. And again, it's a long process. Brought that had to be brought in the Federal District Court in Washington, D.C., and we brought it there, and lost it. Unestablished precedent, but we knew that was going to happen. We pushed it forward. This case only took 3 years, so it was a really quick case. Court of Appeals, and in the Court of Appeals, the judge who, again, we got a 2-to-1 decision. So we had a dissent. We had a judge saying this is all wrong and it shouldn't continue. And the judge who was sitting, the majority, the chief judge actually, had written 2 opinions sustaining this act and wasn't about to change his mind. But you know, since he was only going to say the same thing, we really didn't care. And then we brought it up, and that case was quicker grant, and we heard it in February 27th. I would expect that one to be decided sometime in June. So, having told you that, I hope that just kind of elucidates the process a little bit. I'm trying not to argue who's right or wrong in these cases, but explain what was the basis of bringing them, and what does it really take to get it there. And you know, you can also start to think, what does it cost to get one there? And not only what does it cost the litigants, but in our judicial system, when you think about the investment of the whole system, the lower courts, the courts of appeals, there's a huge public investment in these cases. And, you know, and therefore the Supreme Court, you know, really has to take a major responsibility, because it's not only dealing with issues, it's dealing with the culmination of a process in which the public is heavily invested. So, thank you very much. I'll be happy to answer any questions. You want to ask the first question?
I'd love to ask the first question.
I thought so.
All right.
That's what college presidents are paid. And he's a lawyer, too, so it's, you know.
Be careful. So you had a distinctive perch in 1966 as a Supreme Court clerk.
Yes.
And you have clearly now been litigating in front of the Supreme Court. What are the major changes that you see in the court, or perhaps in the legal system, from when you were a clerk to today, and both for good and for ill?
Yeah, it's a fair question. You know, obviously the court in the 60s was involved in a different era, an era in which the court was a leader in change. The court was very much involved in protection of minorities. You know, you're following on all the aftermath of Brown versus School Board. So you're in an era in which the court is seeing itself in a guardian, protective role. Now I think, again, you know, there are 9 members. They're not all the same, but I think the general view is the court is in a more protective role. It's protecting stability. It's more conservative, as you might say. It is not trying to embark and really push the frontiers of the law in the same way. I mean, clearly, 60s were the culmination of an era in which the court had been the leader in breaking down racial barriers and saying we need equality and we mean equality. And Chief Justice Warren, who was then the Chief Justice, was a governor. And so his method of running the court was much more executive than what you have with John Roberts, who's a lawyer. He saw objectives. He was very, very intent on trying to produce large majorities in cases that were controversial. Let's not take it unless we can get at least 7 votes. Brown versus School Board, they got 9 votes. In sustaining the Voting Rights Act, the first time they got 8.5, and lost Justice Black on one small part of it. But the idea was the country needs unity, and we need to produce unity. So there's a lot of pressure in the conference to find ways to say things that were acceptable. This court is much more willing to split itself up. Some of this happened in the era of Chief Justice Rehnquist because, and this is a kind of legal realism, Justice Rehnquist had a terrible back problem. So when they had conferences, which they hold on Friday to decide the cases, and they try then to kind of come up with some kind of, you're going to write the decision, here's what we all think, this way if you write it, we can all join it, he had no patience. And his favorite word was vote. Get this over with, because my back hurts. And sometimes you'd see him in oral argument literally stand up and stretch with like a signal, I don't want to listen to you anymore, my back hurts. That changed the temper of the court. I think this court has been much more willing to tolerate large splits and to have people write their own thoughts. So that's a difference. The other difference is kind of statistical and interesting. In the 60s, the average number of cases decided was about 150 each year. It's now 70 to 80. And you'd say, well, are they understaffed? No, the iron rule of bureaucracy is it's the opposite. In the 60s, there were 2 law clerks in each chambers. Each justice had 2 assistants. They now have 4. So of course they only have to do half as much because you got more people to discuss it with. You know, the volume of petitions about the same, but and in the 60s, the justices tended each to consider the petitions on their own. That is, your chambers, your assistants kind of wrote up a little summary of the petitions, and the justice glanced through them, looked at the summaries, decided how he was going to vote. And I say he, they were all men at the time, so it's not to be pejorative. Now they pool those. So each of those 4 assistants only does a small percentage of the write-ups. So it takes longer. I mean, it's astounding, but that's a difference. But I mean, the Supreme Court has great continuity as an institution. It hasn't changed the number of members. Still, uses the same format of certiorari, Friday conference, oral argument. I think the one other difference, certainly from an advocate's point of view, is that the court tended to listen more in the 60s. No, if you had half an hour, you could probably figure you could talk for 10 minutes. Now, I think almost everybody who's there will say, if you prepare, you better get it down in 2 sentences because that's the most you're ever going to say before somebody starts after you. And they're more aggressive about their questioning now. It's more challenging. And the one thing I would say is if they go on television, it'll be the end because then it will be a performance. Right now, they're recorded and they release it in the afternoon, but there's no camera. You put a camera in there, devil take the hindmost. So, I think probably it's social change for one thing, it's institutional staffing for another, and it's the temperament and the disposition of the Chief Justice. A Chief Justice controls the opinions. He decides who's going to write the majority opinion. That's a great power because in big cases, people want to write. They want to have their name on that case. And one way you can exercise that power is to say, well, I could give you this opinion if you would temper your view a little bit and corral a bigger majority. If you don't care about that so much, you just assign the cases to whoever really cares and has a strong view on them. So it's a different thing, and it'll take any Chief Justice time to learn how to manage a court, especially somebody who's been a lawyer. Lawyers are much more used to working individually and collegially, not in a hierarchical manner. To be an effective chief, you sometimes have to be hierarchical. You have the administrative responsibility, Roy?
There's been publicity about the fact that it takes 4 judges, like you said earlier,
Right.
to hear a case, but 5 to decide it.
Right.
We're talking about a play this week because of California.
Yeah, the marriage case.
Comment on, and I listened on NPR the other day to the judges and the lawyers, and it takes about 2 seconds, at least for me, to be totally confused. So, could you tell us a little bit about why it seems to be the wrong case, even though it's going to be heard?
The California marriage case?
Yeah.
Well, I mean, what happened in the California marriage case was initially California allowed same-sex marriage. Then a bunch of citizens got together and put on to the California ballot a referendum. You can amend the state constitution in California by a popular vote. It's an old kind of West tradition. And they amended the Constitution to outlaw same-sex marriage. Okay, so the proponents of same-sex marriage then went to court and said, outlawing this is against my right to not be deprived of my liberty without due process of law. And the state was the defendant, because the state was, of course, the owner of the law, it now being in the state constitution. But after the state lost in the district court, they quit. We said, we don't want to defend this law anymore. In fact, we agree with the other side. So you had a case without an opponent. But some of the people who had then sponsored the petition said, whoa, there's an opponent, and we're it. And we're coming into this case. And the Court of Appeals allowed them in. And they were the ones who were the opponent in the Supreme Court. But the court was raising the question, well, are you properly a party? Because there's a general rule that you just can't wander into the court and say, I'm interested in the result. Because then any citizen could sue about anything. And this started with people challenging in their capacity as taxpayer. I don't like the fact that government's spending money on this, and I've got a grievance, and I can be in court. And the court has long said, you can't do that. You have to be distinct from the general run of citizens. So one of the big issues is this group, which is defending the law, just a taxpayer group, just an ordinary group of citizens with a view, in which case they don't belong in court, in which case there's only one side, and you can't have a case. There's no case or controversy when you only have one side. And they could throw the case out that way. Now, will they? You don't know. But there was a lot of questioning about that. Most of the argument was taken up on that issue. So, and then the other case was the Federal Defense of Marriage Act case, which in its own way had a similar issue because the federal government was defending that case, and they also decided they were on the wrong side, and they reversed sides. And so it wasn't clear who was defending that act because congressmen intervened, saying, we passed it, we have an interest in it. Is that interest sufficient? You could have both those cases turn into a big wonderful procedural decision, and I think most members of the public would say, why they bother? Got us all stirred up. We had all these demonstrations. Yes, sir. Mr. Kirby.
From a just curiosity perspective, you take a gal, Fisher, down in Texas, who's obviously passionate, her family's passionate about the perceived injustice, and I don't say that.
Right.
How does she get to a Wiley Rein? And if that's not a question that you're not allowed to answer, in other words, you talk chronologically about 3, 4, 5 years. Obviously, there's an economical or dollar factor involved in that.
Yeah.
Could you tell us that?
Well, I mean, it's one of those things. We had a foundation, which is on the brief, is fully disclosed, which was very interested in bringing a case of this kind. The head of this group was from Austin, and he knew the father. And so when he heard the father talking about this injustice, he said, wow, this is the ideal plaintiff. Will she carry this case? And talked to her. She said yes. And so that's how that case got started. The Shelby County case really was it's a political subdivision. There's a county attorney, and the county council was very much in favor. They'd spent a lot of money. They had never failed to pre-clear one of their changes, but they'd spent a lot of money because it's growing, and they constantly were making changes, and they kept submitting them. It was costing them hundreds of thousands of dollars, and they said, enough. Shelby's a suburb. It's it's 15 miles from Birmingham, but it's very quickly growing because it's a suburb. So, yes, sir. Mr. Penn.
Would you comment on the role and the impact of law clerks?
Well, I mean,
Both their role and their
well, their role is, like any assistant, their role is to help the justices ferret out the cases and make decisions. So one of the things they do, given the mass of paper that's in front of the justices every week to be processed, they summarize. They're people with whom you can discuss the cases, somebody to bat it around with. They don't vote. They sometimes draft. A justice will say, I've got this opinion, I'd like you to write a draft for me. And depending on how much confidence the particular justice has in the law clerks, some of that drafting may find its way into the ultimate decision. But I think it's a mistake to think that, the staff's in charge of the court. The court's very much in charge of the court. And they cannot participate in the conferences. The conferences are private. So when the justices go in that room, if they don't know what they're talking about, they're at a huge disadvantage. So they've got to be ready. I always tell people my greatest experience as a law clerk was Justice Harlan was practically blind, and especially in his later years. And he struggled to read everything. But there are certain things he just couldn't see. And in that year, we had a case where there was a pornography case. It was about a movie. It's called Roth. And there was a doctrine started by Justice Stewart that in order to determine whether something was pornographic or merely also had expressive value, you know it when you see it. So in order to adjudicate this case, the court decided to have a showing in the conference room for the justices of the movie. And Justice Harlan, who was a great believer in process, said, if that's the doctrine of the court, I've got to see it. But he couldn't see it. So I was appointed to go in there and explain what was going on. So that was my greatest experience as a law clerk. But I didn't vote. And also I think you raise a good question, because people have mystical beliefs about what law clerks do or don't know. And Barbara remembers about 3 years ago, I got a call from a lady who said, I'm researching and I'm writing a book on the treatment of gays and lesbians by the Supreme Court. And I said, yep. And she said, and I'm interested in exploring Justice Harlan's views on that. And I said, yes. And why would you think that I could help you? I didn't discuss such matters with him. She said, well, I have his papers, which are in the Princeton Library. And there was a case in front of the Supreme Court. It was a cert petition in which the issue was whether when somebody lied about their sexual orientation at the point of immigration, they could be deported. And the case was really about, what did the statute say? What did Congress, because Congress has arbitrary power over people who can be deported. And so in the world of Justice Harlan, he'd look at the language of the statute and the history of the statute and make a decision, what did Congress want to do? And it happened to be about gays, but I don't think that had any, and so I was trying to explain to her, A, he wouldn't have thought about it that way. B, he certainly wouldn't have discussed his views with me. And C, what do you think I remember about this 40 years later, which was nothing? So she sent me a copy, said, well, when you read it, you'll know. And fortunately, I read it, and all it said was the Congress said this, and the legislative history said that, and it appears that the intent of the Congress was X, Y, or Z. And I think but it is amazing that people attribute to these clerks, all of whom are just either 1 or 2 years out of law school, a power they don't have. Justices are fairly intent on deciding their own cases, and anybody can help with research, but decisions are a different thing. And and I think you'll often say if you read Supreme Court transcripts or if you get lucky enough to go to an argument, they're trying to work on each other. I mean, when they're talking up there, they're not just asking questions to the lawyers. It's not 20 questions. They're working on each other. They have points of view, and they're trying to bring other people to see their point of view. And that's very, because Friday, they got a vote. And they want that vote to be the way they want it to be. Yes, sir.
When you talk about Obamacare, what went on in the court behind Obamacare, the decision last year,
yes,
and what's likely to happen in the future from a judicial standpoint?
Well, Obamacare raised a number of issues, and it was very controversial, and the feature of it that was really, most centrally contested was whether Congress had the power to deal with people who didn't want to be in the health insurance market and say, if you're not in the market, we're going to tax you in a certain way, but penalize you if you don't want to buy health insurance. We want everybody to play. And the idea was it's not going to work if young people opt out and say, I don't need insurance, I'm healthy, because that skews the population to older people and the rates go up. So Obamacare has a mandate in it, and if you don't go along with the mandate, you're taxed. So argument was, Congress has the power to regulate interstate commerce. But if you're not in commerce, how can they regulate you? And there was prior precedent of one kind or another. It was very closely contested. So the court, in an interesting way, there were 5 votes that said regulating people who don't want to be in commerce is beyond the power of Congress, including the Chief Justice. And you say, well, then how did Obama win? The Chief Justice said, and therefore I can't sustain this under the Commerce Clause. But since the form in which the regulation is made enforceable is a tax, then Congress has another power to levy taxes. And so it's a legitimate tax. It's not a legitimate commerce regulation, but it's a legitimate tax, and therefore it's sustained. Interesting decision. So it was like 4-4-1, but since the 1 would say yes, along with a 4 who would say yes on broader grounds, that was how it was sustained. You know, these things happen. And it was a point that was really a throw-in the Solicitor General's brief. You know, the taxing power, but it was the one the Chief Justice fastened on.
Going forward?
Well, going forward, like anything else, you know, that's an unstable situation. And, you know, if you, after all, people change and remove themselves from the court, I think if some of the people who, you know, on the 4 minority who said, yes, the power's there, change, that would give 5 minus the Chief Justice to say, no, it's unconstitutional. That could change. But I think the court would be loath to take it up for some period of time, because I think the court's view is going to be, you know, we had this politically sensitive issue. We decided it. Let's let it run for a while, just because it's, you know, it's too disruptive to the country to bring it up again. Yes, sir.
Well, I asked you the same question.
Oh, well, I hope that I'd give you the same answer, or maybe not. Other questions? Yes, sir.
Is the voting based on intellectual differences or is it really partisan policy?
Well, I mean, you know, that of course is, the Voting Rights Act had a huge majority in the Congress. I mean, there were only 3 votes against it in the House, and the Senate was unanimous. It, you know, it's the kind of thing, it doesn't do you any good to vote against it. Politically, it's suicidal. You're just going to lose a lot of votes. I think that it's certainly been Republicans who have more energetically pushed for electoral changes. You know, as they dominate state legislatures, they do what Democrats used to do and gerrymander. So anytime you block, it looks like you're helping Democrats. And I think people see it as partisan, but the debate over the act was really not partisan. It was more about, you know, when do you oust the traditional power of the states to regulate elections and supersede it with what the dissenting judge in the Court of Appeals called federal receivership. Is that appropriate? You know, what is the dignity of the state? How does the federal system work at the judicial level? I think you've seen a lot of cases under the Voting Rights Act where people are contesting things like photo ID. And, you know, saying, well, look, it's unfair to people who are poor and old and don't have photo IDs, and therefore it's discriminatory, but a lot of that is partisan because they're trying to figure out how do those constituencies vote. And one of the problems when you're looking at districting is that districting is traditionally a political exercise. Everybody fools around with districts to get the majorities they want. So to identify when something is racial versus political is very difficult because the racial votes line up with political votes. You know, if they didn't, you wouldn't be able to, you wouldn't get mixed up, but they do. You know, minority communities vote Democratic, and therefore Democrats want to protect them. But a lot of it is just incumbency. The Voting Rights Act was a strong protector of incumbents, and incumbents like to be reelected, and you know that's their job. And as long as you know people have that inclination, I want to be reelected, they'll want to make sure those districts are favorable to their reelection. So, anybody else? I think I exhausted the crowd.
Please join me in thanking
Thank you. Pleasure to be here.